Good morning and welcome to this Espresso coffee break briefing, our 8th coffee break briefing of this year. We've had quite a busy time actually with various announcements coming out that I've tried to catch up with in coffee break briefings. So we had the frequently asked questions on tax in personal insolvency that we covered last month. We've got the Dear IP guidance on the due diligence that you should be doing when providing information to the RPS, and we're covering that in our routine coffee break briefing next Monday, so we've got 2 in August. Goodness only knows why we're doing this in August. I mean, should we all be off on holiday in the Dordogne or on the Algarve, or at least at Muddyford, which is the beach shown in the background to all of this. But anyway, we're here. So today we're going to be talking about the recent High Court decision in Novalpina and what that has done to MVLs. And I'm planning to follow that up in September, where the coffee break briefing there will be one where I look at the Section 95 procedure just as a useful refresher, and in case you're finding yourself having to do some Section 95 conversions into CVLs. And after that, we'll probably be back onto the usual run of old cases that none of us can remember terribly well, and old law. Monday's coffee break briefing, of course, where we're looking at the RPS guidelines. We'll have a guest presenter joining me for that, and that's Chris Dobbs from my firm's employment law team. And those of you who saw Chris's presentation at our conference in June will know just what an excellent presenter he is. So I think that's going to be a coffee break briefing that I think you'll find useful, and I hope you'll enjoy. So with all of that, that's the introductory stuff out of the way. Let me now start the presentation itself. Welcome. Today's Espresso coffee break briefing is going to be talking about the High Court decision in Novalpina and the implications for MVLs. And the key thing about this decision, and the reason why we've decided to convene this extra coffee break briefing, is because it's run against what everybody seemed to think was the established law and practice, which was that it's okay for an MVL to run more than 12 months, even if you're not paying creditors within that time, just as long as the MVL is balance sheet solvent and is going to be able to pay those claims in full at some point in the future. And Novalpina says, no, that customer practice is wrong. So let's dive into the detail of that, and I'll just go through the points that I want to cover. So I want to start by running through the facts of Novalpina itself, just so you know a bit about the MVL that was running in that particular case. I'm then going to look at what the law is, and in particular look at sections 89 and 95 of the Insolvency Act, and then look at the way that those provisions were interpreted in the Novalpina decision. Then I'll be looking at a question that I've been asked a few times since the Novalpina decision early in June, which is, how binding is it? Is it going to be appealed? Can we just ignore it? And then I'll be moving on to talk about, firstly, how the law affects the MVLs that you might have running at present, or the ones you might be looking to open in the immediate future. And then I'll be looking at some wider implications of the Novalpina decision and where it leaves the balance of power and the utility of an MVL as a procedure for some of the perhaps less common uses for it. So let's start with the background to the case and just run through the facts in Novalpina itself. In some ways, it started as a fairly routine members' voluntary liquidation. It was opened in May 2023, and the declaration of solvency showed net assets of around £148,000, so quite a healthy balance there. Now, admittedly, a big part of that balance was represented by debtors that needed to be collected, but they were thought to be good and properly valued in the declaration of solvency. Things started to get difficult fairly soon after that, and by October, so within about 5 months of the MVL starting, a creditor had popped up and was now suing Novalpina in the courts in Luxembourg. And there was some discussion in the High Court decision in Novalpina about what the value of this claim was likely to be. And there are a couple of figures I saw in the judgment. One was that the claim was estimated by the creditor to be for around 14.4 million euros, and the creditor at a different time estimated that their claim was for around 287 million pounds. So whichever figure you choose, very much more than the net asset value of the company, but a claim that was heavily disputed. And there were a series of liquidators in the Novalpina MVL, and the key liquidator at the time when this decision had to be made assessed the claim of the creditor as probably amounting to nothing, effectively valuing it at zero. Now, fairly soon after the creditor had sued in Luxembourg, they then lodged their claim in the MVL, and they started to talk about whether the MVL should therefore convert to a CVL, on the basis that the company now looked like it was not going to be able to pay its debts in full, and they issued a High Court claim to get a judge to rule on whether the MVL should be converted into a CVL, and that question was adjudicated on in the High Court on the 6th of June, which is when the case was handed down. And by that time, the value of the assets in the MVL were very much lower than had been originally disclosed on the declaration of solvency. In particular, the debtors were proving very difficult to collect, and it looked as if they might be irrecoverable, which would have left the company with a much lower net valuation. I'm now going to look at the law on when you convert an MVL into a CVL. And there are two provisions in the Insolvency Act that are important here. There's Section 89, which deals with the original declaration of solvency, and there's Section 95, which deals with the circumstances in which a liquidator should convert the MVL into a CVL, and the broad outlines of the procedure for doing that. So let's dive into Section 89, and this is, as I say, this is about the declaration of solvency that the directors swear to put the company into an MVL, and of course this is the crucial document for putting a voluntary liquidation on the MVL track rather than the CVL track. If there is a declaration of solvency, you're on the MVL track as long as you follow the other procedures for getting the company into liquidation within the time limit. But it's basically the declaration of solvency is the document that puts the liquidation on the MVL track. If there is no declaration of solvency, it's a CVL. And in the declaration of solvency, the directors have to confirm that they have actually looked in some detail at the company's financial affairs, and on the basis of having done that, they think that the company will be able to pay its debts in full within 12 months. Now, they can set a shorter period than 12 months in the declaration of solvency, but nobody ever does so. So for the rest of this presentation, I'll be talking about 12 months as being that period set by the declaration of solvency, and say it is almost always going to be 12 months. So that's the key thing, is that directors have to effectively put their necks on the block and say that they think that the company has the wherewithal to pay its debts in full within 12 months. And there are other parts of Section 89 that are important as well. Section 89 2A sets a 5-week shelf life on the declaration of solvency. So the declaration of solvency is valid for 5 weeks. If you don't start the liquidation within those 5 weeks, it's then going to be a CVL unless you get a fresh declaration of solvency done. The second part that's important is subsections 4 and 5 of Section 89 put the directors at risk of prosecution if the declaration of solvency turns out to have been over-optimistic. And the directors are given a bit of wriggle room on that. Essentially, the way that subsections 4 and 5 work is to say that if the company fails to either pay its debts in full or to provide for them in full within 12 months, then there is a presumption that the declaration of solvency was not properly made. The directors did not have reasonable grounds for swearing it, and if the director cannot show that he had reasonable grounds for swearing the declaration of solvency, they can be prosecuted. So that's the part of the insolvency legislation where the idea of being able to secure debts if you can't pay them in 12 months comes in. But all that Section 89 4 and 5 do is they give a defence to a director, so that if the MVL carries on for more than 12 months and the debts have not been paid in full, the director can then be protected from prosecution as long as the company still has sufficient assets that it will be able to pay the unpaid debts in full at some point in the future, even if it's more than 12 months. But it's only protection for the directors. Section 95 is the one that's triggered by the potential insolvency of a company in an MVL. And a liquidator has to follow Section 95 when you think that the company is going to be unable to pay its debts in full within 12 months. And there's no reference in Section 95 to securing the debts or providing for the debts for payment after 12 months. The key thing is that Section 95 is triggered at the point where you think that the company is not going to be able to pay its debts in full within 12 months. And you have to act pretty fast on that opinion once it hits you. You've got only 7 days to prepare a statement of affairs and to send it to the creditors, so really not long at all. And you've then only got 28 days as the date within which the decision date for appointing a new liquidator has to be set. So you may find that within 28 days of realising that the company is going to be unable to pay its debts in full within 12 months, you've actually got a new liquidator in who's replacing you. And it is, of course, the creditors who will choose the liquidation in a CVL, and will do so if it's a CVL that's formed on a conversion from an MVL under Section 95. So that's the law. Now, the judge in the Novalpina case did go into the law in a great deal of detail, and she emphasised the way that the law should work, that 12-month rule is a strict one, and you have to convert the MVL into a CVL if you are unable to pay the debts in full within 12 months. But the main grounds for the decision in Novalpina were actually on the facts of the case, and the facts here were that by the time it got to court, the costs of the liquidation, I guess particularly dealing with a heavily disputed claim like this, had actually exhausted the funds in the liquidation. They'd all gone in expenses at that point. and there was a third party, I guess probably a shareholder, who had stepped in to cover the costs of the liquidation to keep the MVL running. And the judge said, well, that just shows that the company is now unable to pay its debts, that liquidation expenses are themselves debts of the company, and if you cannot pay the liquidation expenses in full, then you have to convert to a CVL. And she said that's the case even if somebody else is actually paying those expenses for you. And she said that a claim of only £1 in those circumstances will trigger the need to convert the MVL into a CVL. And she also looked at it was one of the liquidators who had assessed the creditor's claim and put a value of 0 on it, and she was unimpressed by that and said that you have to value the claim at something in the circumstances, in the particular facts of this case. And she didn't express an opinion as to what that figure should be, but it was more than 0, and a claim above 0 in a case like this that was not paid within 12 months of the start of the MVL triggered the need to convert into a CVL. So the key points of law about this, the key points to take away to your own cases, are that there is a duty in an MVL to pay all creditors within 12 months. And if you can't pay all creditors within 12 months, whatever the reason, you have to convert the MVL into a CVL. If you can pay but you don't pay within 12 months, again, you have to convert into a CVL. It is a very hard cut-off after 12 months. And creditors' claims in these circumstances, of course, include claims that are contingent, that may be disputed or unquantified. They're claims that you cannot put a figure to. And of course, there is a procedure in the Insolvency Act for valuing creditors' claims in situations like this. And if you can value them, and if the valuation is accepted by the creditor, you can then pay them. And if you do that within 12 months, then there's no need to convert into a CVL. But again, one of the issues that came across very clearly in the Novalpina decision is that it may not be quick, simple and easy to get rid of a claim by valuing it, because if the creditor appeals, the appeal itself can open up into a very substantial piece of litigation. And the judge said that in a case like Novalpina, the only way that an appeal could reasonably be run would be with a full trial, with witnesses, cross-examination, lots of wigs and gowns and Latin, very expensive, very time-consuming, and she felt that probably anything like that in any event would itself then be adjourned until after the Luxembourg courts had dealt with the dispute. So Novalpina, there was really no shortcut for the liquidator to value and assess the claim and quantify it and pay it as a way of getting rid of it. I've got some diagrams here to try and I suppose draw a picture about MVLs and Novalpina. And here we've got the MVL box, and the horizontal dotted line is the value of the company's assets. And as long as the creditors who have to be paid amount to less than the value of the company's assets, then it will stay in the MVL box. And as long as those creditors are paid within 12 months, which is the vertical line, then it will stay in the MVL box. If the value of the assets are greater, so if the value of the company's assets are less than the value of the claims against the company, then that puts the company into the CVL box. And at the point where the liquidator realizes that the liabilities are going to be greater than the assets within the 12 months, then the liquidator is duty bound to convert the MVL into a CVL. And similarly, if the liquidator starts starts by thinking that all of the liabilities are going to be paid within 12 months, and then realizes much later that it's likely that the liabilities are going to exceed the assets, even if that figure is not going to be known, even if that's not going to be certain, until more than 12 months has gone by, then the liquidator is probably going to have to convert the MVL into a CVL. And the Novalpina zone is where the liabilities are going to be manageable by the company. The liabilities will amount to less than the value of the assets, so the company will be able to pay those liabilities in full. But if the company is, as a matter of fact, not going to be paying them within 12 months, that takes you into the Novalpina zone, and in the Novalpina zone you have to convert the MVL into a CVL as well. So, question that I am being asked is, well, how binding is Novalpina? And I think this is because it's been a bit of a shock to the profession, including myself, because it has gone contrary to established custom and practice. And established custom and practice is a form of insolvency law. However, it's a form of insolvency law that can be overturned by a High Court judge, and from time to time is overturned by High Court judges. So, yeah, in terms of, do you carry on with custom and practice, or do you follow the decision in Novalpina? You follow the decision in Novalpina. So the question is, well, is it going to be appealed? I have heard that it is going to be appealed. Whether it will be appealed, I don't know. What the result of that appeal is going to be, I don't know. But it does look as if the decision in Novalpina is pretty close to the direct reading of the words of Section 89 and Section 95. So I'm not sure I'm going to put a lot of money on the prospects of this decision being appealed successfully. It won't necessarily bind another High Court judge, and that's because, although High Court judges are very authoritative, nevertheless another High Court judge would be entitled to come to a different conclusion on a similar set of facts. But the Novalpina case, it's 63 pages long. I've read it, so you don't have to. It's very fully reasoned. I think it is likely that other High Court judges will follow it. So if you're in a similar situation and you're wondering whether to seek directions from the court about whether you should convert your MVL into a CVL or not, chances are that the Novalpina decision is going to be the one that you should observe. So in terms of looking at your own MVLs, what are the sorts of issues here? Well, I think you probably need to review certainly the older MVLs that you've got, certainly those that are more than 12 months old. And I think the place to start is probably the contentious ones, the ones where there is a risk that your decision might be challenged, either with a grumble to the regulators or through the courts. It makes sense to get those ones cleared out of the way first, get your decision made on those first off. Then I think you should look at every MVL that you've got that is more than 12 months old, just to see if any of them are ones where you have not yet paid creditors. If there are MVLs you've got that are more than 12 months old and you haven't paid creditors and the funds are there to pay creditors, then I suggest you get on and pay those creditors as soon as you reasonably can. If you've got cases that are more than 12 months old, where creditors have not been paid, either because the funds are not there, you should certainly convert those to a CVL, or because there is still some sort of evaluation process going on to assess the claims, then those also you should perhaps be converting into CVLs. And I think it makes sense to review the MVLs that are less than 12 months old as well. Perhaps have a look at them when they're 6 months old and make sure that you know all of the MVLs of that age which have still got claims that are needing to be dealt with, and then review those cases regularly, perhaps with the frequency of review increasing as you get close to the 12-month point, at the point where you may have to convert to a CVL regardless. You should be reporting to directors and shareholders on those cases which are at risk of having to convert to a CVL, including cases that have been running for only a few months, just to make sure that they are aware of what the potential risks are of a conversion and what the consequences might be for them of a conversion. You should perhaps have a look at your engagement terms to see whether you want to rewrite those at all in terms of the content you've got there, the guidance that you're giving to directors and shareholders about the risk of converting into a CVL and the implications of that for them. I think many firms are going to want to review their pre-appointment reviews to see if they need to tighten those up at all. And I think they'll be looking at whether they need to be asking extra questions, asking for additional information, just to try and filter out those cases where there is a dispute with a creditor being carried across into the MVL, because those are the cases that I wouldn't say you don't necessarily want them, but you should be taking them on only on the basis of a proper informed decision by yourself, the shareholders and the directors about how those cases are going to be dealt with and how you're going to deal with the need to convert them. And if you're looking for a second opinion, then by all means take legal advice and get a review of the particular circumstances of a particular case that seems to be complicated or a bit difficult in terms of which way you should go with it. And in terms of the wider implications for MVLs, I've got a few here. You'll probably be able to think of others. One is that I think there could be greater opportunities here for difficult creditors. If you've got a creditor where you're trying to reach agreement on what their claim is, then there's actually a bit of moral hazard here in that there is an incentive for them to drag out the process, because if it goes on for 12 months, then the liquidation converts into a CVL, and in many CVLs they could be the only creditor, so they would get to decide who the liquidator is. New liquidator comes in, replaces you. New liquidator may have a very, very different perspective on what an appropriate settlement figure might be for this particular creditor's claim. It could be much more expensive for the company than dealing with it in an MVL. Second thing is, I think it's going to be important to value and deal with disputed claims sooner. So if you're going into an MVL with your eyes open on the basis that there is a claim by a creditor that is going to need to be assessed, valued and paid out, you're going to need to start that process quite early on in the MVL to try and get it concluded within the 12 months. And as I said earlier, one of the issues with the Novalpina decision is that it can actually become quite expensive to resolve a case like that through the courts, with it possibly going to a full trial in some cases. We may find that in some cases, counterintuitively, that it's in the interest of shareholders for them to lend money to their company before it goes into liquidation. Consider the case where there is a known dispute that is going to be dealt with in the MVL. The estimate is it should be settled for less than, let's say, £50,000. It might make sense for the shareholders to lend £100,000 to the company, so that if there is a conversion to a CVL, they will be the larger creditors and will be able to choose who the liquidator is going to be, rather than the creditor doing it. Now, a a lot of shareholders are not going to like that idea. The whole point of an MVL normally is for them to take money out of the company rather than put more in. But there may be cases when it's sensible for them to do the opposite. We may find that there are fewer MVLs. If the pre-appointment reviews filter more out, I think that's quite foreseeable, quite possible. And the final point I got there is that MVLs may become less useful. And I'm thinking here of a situation where hypothetically you might have a lease which is proving difficult to sell, difficult to get rid of, and it's a continuing quarterly liability. So the decision might be to put the company into an MVL and for the liquidator to disclaim that lease immediately on appointment, which then converts the claim of the creditor from an ongoing quarterly rent claim to a single claim for damages for breach of contract, and then that claim could be assessed and paid, and then the liquidation can be closed. Now, you might find that the landlord in a case like that is more likely to argue about the case, more likely to try and drag it out, simply to try and get to the point where the MVL converts into a CVL and they get to choose who the liquidator is. So you might find that when you're running through that option with shareholders, they might think that actually they'd rather carry on negotiating with the landlord outside of an MVL rather than put it into an MVL and try and resolve it that way. So I think that's covered all of my points. I think I've got a few questions which I have not looked at so far, so let's now see if I can pick up some of those questions. Now this is an interesting one. This is John Rimmer saying that his regulators have advised that they would be conflicted to act as a CVL liquidator following an MVL liquidator appointment. And if there are no creditors who vote, particularly where there's only one contingent creditor upon the appointment of a liquidator, what happens? Well, I'm slightly puzzled by that advice about there being a conflict with you continuing in office as a liquidator in a CVL. I can see there are cases when that would be so, but there are also, I think, going to be many cases where that's not going to be the case, particularly if the claim of the creditor is relatively modest in terms of the assets of the company. I'm surprised at that. And if there are no creditors who vote, then you will continue in office as a liquidator because you are appointed as liquidator when the winding up resolution is passed, and the Section 95 procedure gives creditors the chance to vote on who the replacement liquidator is going to be. Now, if it is important to replace the liquidators, if there is a conflict, if you're unable or unwilling to continue in office, then you can find, assuming there are assets in the case to do this, you can find another insolvency practitioner to act as liquidator, and you can use the deemed consent procedure for them to be appointed in your place, and that will then mean that if the creditors do not engage and just let the resolution go through on the nod, then you will change the liquidator in that way. So deemed consent, I think, would be your friend in a case where you do have to change the liquidator, but I wouldn't have thought it would be necessary in every case. Now, let's see. Yes, and we've got a question here to say, is it right to say that creditors must actually be paid in 12 months? Isn't the Section 89 wording paid or provided for? And the Section 89 wording, where it refers to paid or provided for, that actually is just the part of Section 89 that gives a defence to directors in cases where creditors are not paid within 12 months. but the declaration of solvency that the directors have to swear is for them saying that they think that all creditors will be paid in full within 12 months, and the Section 95 trigger to converting into a CVL is triggered by non-payment of creditors in full within 12 months. So yes, I think the Section 89 wording has actually provided a lot of comfort for the profession in the past, because, as I say, the custom and practice has been to run MVLs for more than 12 months. Question from Nicola Leyland saying, where there's an indemnity, would it be appropriate to make a call on that first before reaching the conclusion to convert? It may well be, and yes, and I think probably it would be, just because just thinking through that question, the situation in which you would have taken an indemnity is usually where you've made an early distribution to shareholders. Normally, the statutory procedure is for you to advertise for creditors' claims, to agree creditors' claims, pay creditors' claims, and only then pay shareholders at that point. Again, custom and practice has been to give shareholders most of their money as soon as you're appointed, on the back of an indemnity, on the basis that if you then need that money to pay expenses and creditors, you can call for it back. So yes, I think it probably would normally be appropriate to call on an indemnity, to call money back from shareholders if you're unable to pay the claim in full within 12 months. But probably there's going to be some other reason why you haven't paid within 12 months. But then again, it probably makes sense if you're going to be handing the case over to a CVL. It would make sense, I think, to pay to get the money back from the shareholders. Another question from John Rimmer saying, if there is a contingent claim which turns out not to be a claim, do we still need to convert? And the answer to that is all about timing. If there is a contingent claim which is still a contingent claim at 12 months, you would have to convert into a CVL. If within 12 months the contingent claim turns out not to be a claim, then you don't need to convert because it's not a claim. But if there is a contingent claim that is in existence, and if it's going to be worth even a pound, if that's sort of the valuation you're making for it at that point, then you do need to convert. If it's a contingent claim with absolutely no merits whatsoever, then you might be able to disregard it, but that's going to be, I think, only in very unusual circumstances. Let's look at more of these questions. Next one is, what if HMRC have taken more than 12 months to pay a pre-appointment refund to enable the liquidator to pay to other creditors? Question from Daniel Wright here. Well, I think if you have the situation where the declaration of solvency is based on paying all creditors in full within 12 months, and if the only reason why you have been unable to pay all creditors in full within 12 months is because you're waiting for a refund to come in from HMRC, I think you have to convert it into a CVL in that situation, because as a matter of fact, you have failed to pay all creditors in full within 12 months. And you might find that the shareholders at that point would be willing to deal with the creditors themselves. They might pay the creditor themselves, they may provide funds to allow you to do that. There may be other ways of doing that, but the rule is if you have not paid creditors in full within 12 months, for whatever reason, you have to convert. Let's see. Question from Stacey Brown about why does the legislation anticipate an MVL liquidator submitting and filing progress reports following the anniversary? And going on to say, does this then only cover a situation where there is an asset to recover within 12 months, so recover beyond 12 months but no liabilities? Well, yes, you've answered your own question. That's exactly what it's for, and the judge did look at this in some detail in her ruling. She said, yes, the reason why MVLs may continue beyond 12 months is because there may be assets to realise, or there may be issues with dealing with shareholders, dealing with their claims, and it's legitimate to continue an MVL for more than 12 months to deal with issues like that, but you should not be continuing an MVL for more than 12 months to pay creditors. Let's see. Question here from Adam Stevens saying, what happens if a liquidation expense develops 12 months on? Presumably you have 12 months on from that new date. Well, actually, no, you don't. So the situation here might be where you're 15 months into a liquidation and then you get a completely out of the blue, unexpected claim, either as a liquidation expense or by a pre-liquidation creditor. And I think the question would be then, can you pay that immediately or not? And if you can pay it as soon as the claim is made, then I think it would be legitimate to continue the MVL. But I don't think you can continue the MVL for 12 months to allow yourself to pay it. I think if the claim comes in and it cannot be quickly and speedily resolved, I think at that point you would have to convert to a CVL. But that's certainly an interesting question. My gut feeling is that you would have a reasonable time to pay that claim. You shouldn't just convert to a CVL and then have to pick it up from there. I think you would have a reasonable time to deal with it, but how long a reasonable time is of course always a little unclear. And Syra Mirza has sent a reference to the Insolvency Code of Ethics 2520.4, conversion of members' voluntary liquidation to CVL. Yes, saying where there has been a significant professional relationship, you may continue, subject of course to creditor approval, but only if the insolvency practitioner concludes that the company will eventually be able to pay its debts in full together with interest. But the insolvency practitioner should also consider whether there are any other circumstances that give rise to an unacceptable threat to compliance with the fundamental principles. So that's very helpful. Thank you for that. So that is then saying that if you're having to convert to a CVL, but it's basically going to be a solvent CVL, you can continue in office as a liquidator as long as the creditors approve you remaining in office as liquidator. But if it's going to be an insolvent an insolvent CVL, if the creditors are not going to be paid in full, then you should get a new liquidator appointed. And of course, that could be problematical in some cases if the assets are insufficient for another liquidator to be interested. Let's see. Now, Danny Wright has a question here saying that consider a case where the company made a pre-appointment payment on account for a 13-month period for tax. HMRC only recognised a 12-month period, paid a refund for the 13th month, and is now claiming the 13th-month tax is due, and the case is over 12 months old now. So that looks like you've got a contingent claim there with HMRC. And I think that if that can't be resolved quickly and speedily, I think you may have to convert that into a CVL. Again, this is one where you might want to take legal advice before you come to a final decision on that. And just thinking about the last point, again, presumably this is one where if you have to convert to a CVL, you're looking at paying all of the creditors in full, so you should be able to continue in office as liquidator, subject of course to HMRC not kicking you out when you send your deemed consent through. Jeremy Knight saying, if the only creditor is a director or shareholder, I suppose it could be another creditor as well, who says that they are happy not to be paid until after 12 months, do you still have to convert to a CVL? I think that's a really interesting question. I think the technical answer is that yes, you would have to do so. The practical answer is, well, what harm is actually being done by continuing as an MVL? And again, the counter argument to that is to say, well, if the only creditor is a director or shareholder whose interests are largely aligned with the interests you've been carrying out anyway, then again, what harm would be done by converting into a CVL? You'd send out a few notices, you'd run a deemed consent procedure, and you'd carry on in office, presumably. I think that's one where the safe thing to do might be to convert into a CVL. We'll have to see what attitude the regulators take to a case like that. Certainly I agree that pragmatically there's a lot to be said for just continuing with the MVL, but I'm not sure that that would be consistent with the legal situation now. And I think the last question I've got to answer now from Joseph Clayton saying, if there are assets to be recovered, but there are costs attached, for example, agents, CFA debtor recoveries and so on, would those costs constitute a liability? I think I would not regard them as a liability. I think what the judge said in the Novalpina case is if the expenses exceed the assets, then a single outside claim will certainly trigger the requirement to convert into a CVL. I think it would be reading too much into the case to say, well, if there are assets that need to be recovered and there are costs associated with the recovery of those assets, and those costs are going to be paid as they're incurred in more than 12 months' time, I think it would be reading too much into the case to say you have to convert a case like that into a CVL. So I think I have now answered all of the questions. I will just have a look and see. I think I have. If you've asked a question and I've missed it, please email me afterwards. If there's a question that you think you might like to ask, please email me afterwards. If a question occurs to you after we've logged off from this, again, drop me an email. I'll be happy to think about it. Thank you very much for all of the questions. I've gone on for an extra 20 minutes to answer them, which I think is an all-time first for a coffee break briefing. But this now brings my presentation to a close. So thank you all very much for logging on today, and I hope to see many of you next Monday when we're going to be talking about the next coffee break briefing, which is about the verification that you need to do for the information that you give to the RPS. So once again, thank you all very much and goodbye.